Stop.
Nah, you need to tell me. Nah.
Okay, it's for battery.
Battery?
Yes.
On who? I ain't hit nobody.
Listen, undo the seatbelt and come out and talk to me.
Man, I didn't do nothing.
Okay, that's fine. We'll talk about it in a second.
Why I got to step out the car though?
Because you're coming out with me, okay? Step out.
Oh, damn, what did I do?
Turn around.
Man, I ain't do nothing. Why you stop? Look at this.
On September 5th, 2022, in Florida, a uniformed officer executed an active arrest warrant on a man during a vehicle stop. What unfolded in the next 11 minutes raises questions that go straight to the core of Fourth Amendment law.
Huh? Mr. Huh? I need you to step out of the car and talk to me. Alright. Hey boss, you roll the window down please? It's for him. Alright, hey, I'm gonna open it. Alright. Hey, I need you to step out and talk to me, okay?
No, I'm not stepping out.
Hey, listen.
Listen, sir.
Hey, sorry, this has nothing to do with you,
Listen,
okay?
sir.
Can you just turn the car off for a second?
No,
Hey.
for what?
Javaris.
Man, I didn't do nothing.
Okay, hey, listen. I need you to come out and talk to me, okay?
What, am I under arrest?
Huh?
I got a warrant?
Yes, you do.
For what?
Huh? I'll tell you about it once you come out. Dude, don't make this harder, okay?
Alright, man.
Let's just get it taken care of, alright?
Why you ain't telling me I have no warrant?
Huh?
What I got a warrant for?
I'll tell you once you step out, man. Come
Nah, what I got a warrant for?
Dude, stop.
Nah, you need to tell me. Nah.
Okay, it's for battery.
Battery?
Yes.
On who? I ain't hit nobody.
Listen, undo the seatbelt and come out and talk to me.
Man, I didn't do nothing.
Okay, that's fine. We'll talk about it in a second.
Why I got to step out the car though?
Because you're coming out with me, okay? Step out.
Oh, damn, what did I do?
Turn around.
Man, I ain't do nothing. Why you stop? Look at this.
3 dispatch. I'm gonna need a supervisor for use of force. Stop, bro.
Business 242. Scratch copy.
So I got a warrant.
Yes.
For what?
Aggravated battery.
Oh, who?
Three dispatch, 1015, one black man. Come on, man. Why would you do that?
Who's in the car?
Huh? He's good. Just keep eyes on him, please. You gotta open the door, man. Open the door.
Go ahead, open the door, man.
Hey, you're good. He's good.
I got insurance. This is my car.
Just put it on the roof real quick, man.
I don't know what's going on, bro.
This your insurance?
Yeah.
And your ID?
That's my license right there, sir.
Alright.
Come on, man. Why the hell would you do that? Seriously? You have any weapons on you? Stop. Do you have any weapons on you? Are you alright for one? You need an ambulance?
Man, what? How I got a warrant, man? I didn't do nothing to nobody. What battery?
Hey, I wrote the warrant.
For what?
For aggravated battery.
For what? I ain't got into nothing with nobody.
With Amber.
I didn't do. What the fuck?
Okay. Alright, hey. Do you have any weapons on you? Do you need an ambulance?
Yeah.
Do you do?
Yeah.
3 dispatch. Rescue my location. 1 black male, conscious breathing. Requesting routine.
Oh man, why you got to stop?
So you just tried to run from me?
Yeah.
You think you beat me? God damn. Jesus. Are you okay?
Yeah.
Sure?
When you finish getting a signature, just bring your warrant request to me.
Man. Hang on him for a second.
Unless you want me to go confirm it.
I'm gonna do that. Just hold on to it. Dude, are you alright? Let me see your face. Let me tear my freaking pants. Face him that way. He's gonna try to run.
What you got? Here's course.
Hang on, I gotta get my life.
What's up? I don't know if you dropped this.
I can check the door.
Yes, you're free to go, my friend.
All right.
Hey, I appreciate you. Sorry about that.
I called the bloke.
Oh, it's all sand, right? Is this your bag or his bag?
I ain't got no bag.
So that's his bag?
I ain't got no bag.
So this is not your bag? No? Okay. This your wallet?
Yeah, that's mine.
This is your wallet?
Yeah, that's my
Okay.
wallet.
Huh? Yeah, those are his. Not his. This guy's. Is that your bag? Alright.
It's on my blonde, man.
What is it? You have any needles on you?
No, I don't have none.
You got so many freaking girls calling on you, I don't even know who you're dating no more.
What you mean?
None of them? They're always over there messing with your house. Under your boxers. No. Front layer or the bottom?
Forty-two dispatch to 97.
Damn.
Show 1065, 1092. Your subject has a 1092 out of the SO, reference simple battery, domestic violence. That is confirmed.
I gotta search you a little more. Anything else on you?
No.
Any drugs? Anything else that goes into jail is gonna be additional charge. Where's that?
I don't got nothing.
Okay.
No drugs in yours?
No.
Nothing in your shoes?
No.
Alright, he's good to go with that.
Open that up, bot.
Hey, Sarge. Can I talk to you?
What's happening?
I don't understand how I have a warrant. I haven't got into anything with anyone. I haven't helped. Sarge, I ain't no violent person, Sarge. They say the girl say she got kids. I don't got no kids from this girl.
All right. Well, let me. I'll go pull it up and see what it says and see who, what it says it's over. I don't know what the warrant's for. So
I didn't do nothing. I'm just saying, Sarge. How can I have a warrant?
Someone wrote it. It wasn't necessarily us, but I'll go take a look and see who it says it's from.
But how can they write it if I ain't did?
I don't know, man. I haven't even taken a look at it yet. Once I do, I can tell you. But let me go take a peek and I'll let you know. All right.
You went down to check your vitals, man, or what you need?
I just want to know how I get a warrant from that. That's all. I'm just trying to understand.
But we'll explain that to you. But for right now, do you need rescue to finish checking you out?
I'm alright.
You're good?
Alright.
Okay. All right, man. I appreciate it.
No problem.
What's up, buddy? I did, man. I'll tell you, we'll have a lot of time to talk.
I didn't even say
She had a witness.
Huh?
She had a witness.
A witness to what? I got witnesses.
I tried to make contact with you. You weren't there.
When you trying to make contact?
I'll talk to you.
When you trying to make contact with me?
That same night.
What's your name?
Taurus, 9 mil.
I'm in
My
Orlando.
driver's seat. You been in Orlando?
Yeah. So you saying you tried to make contact with me?
Yeah.
When?
30
Where?
10:15 1 black male, 51 SSO.
Huh?
The night it happened.
Ain't nothing. What did you talk? What? Ain't nothing happened.
Okay.
What is you talking about, sir? I'm
Hey,
dead serious.
I'm telling you. So,
Sir, if you look at my record, I don't have no record for beating those females, man.
dude, I've never had a problem with you doing that before.
So what's going? So how I get a warrant for it?
Because she had injuries.
Well, not from me.
She had a witness saying it was you too.
36.
A witness saying what? When?
When I pull the date up, I'll tell you. Dude, if I could have found you and talked to you that night, it would have been freaking. But you was gone.
What night, bro? Ain't nothing happened. What night? What is you talking about?
All right.
I just told you, man. I don't beat females. I don't hit females, man. I got 7 baby mamas, man. I don't hit females, man. I take care of all my kids. She not one of my baby mamas, man.
She says you guys have 2 kids together.
I don't got nail child for her, man. Not one. So what that tell you?
Dude, I had to go off what I had there.
How? She lied. How? She came to you and said, I got kids. How?
It was right in front of your house.
What was right? How? What was in front of my house? I ain't seen her.
Her face was busted. She said you hit her.
She was been fighting females, man. I don't beat females. She been fighting females, bro. She been fighting females, bro.
Let's be clear about something from the start. When a valid arrest warrant exists, the law is not on the fence. Under the 4th Amendment of the U.S. Constitution, a warrant issued by a neutral magistrate upon a showing of probable cause is presumptively valid. The subject's first instinct was to stay in the vehicle and demand an explanation before complying. That instinct is understandable, but it is legally wrong. The Supreme Court settled this in Pennsylvania v. Mims. 434 U.S. 106, decided in 1977. Mims holds that an officer conducting a lawful stop has the absolute authority to order a driver out of the vehicle, full stop. That ruling requires no exception for warrant arrests. The command to exit is lawful the moment the officer issues it, and the obligation to comply is immediate. When the subject continued to refuse, his non-compliance crossed a legal line. Under Florida Statute Section 843.02, resisting an officer without violence is a first-degree misdemeanor. The subject was no longer exercising a right. He was committing a separate offense. Once physical resistance began, the officer's use of force becomes the central legal question, and here. The controlling standard is Graham v. Connor, 490 U.S. 386, decided by the Supreme Court in 1989. Graham instructs courts to evaluate force through the lens of objective reasonableness, judged from the perspective of a reasonable officer on the scene, not with the benefit of hindsight. 3 factors guide that analysis: the severity of the crime, whether the subject poses an immediate threat, and whether the subject is actively resisting. All 3 factors weigh toward the officer here. The underlying charge is aggravated battery under Florida Statute Section 784.045, a second-degree felony. The subject was actively resisting a lawful command, and the officer had no reason to believe the subject would stop resisting voluntarily. After securing the subject, the officer did 2 things that matter significantly under Florida law. He called for a supervisor to report the use of force, and he requested rescue for medical evaluation. Both actions are consistent with Florida Statute Section 776.05, governing lawful use of force by law enforcement. The post-arrest search is also legally sound. Under Chimel v. California, 395 U.S. 752, decided in 1969, a search of the person incident to a lawful arrest requires no additional warrant. Officers may search the person and the area within their immediate control at the moment of arrest. Now let's talk about what the officer did not have to do, but did anyway. He disclosed the nature of the warrant before initiating physical contact. The Fourth Amendment imposes no such duty. But disclosing that information early, rather than late, is consistent with de-escalation best practice. It just did not work here. The sergeant's arrival and his handling of the post-arrest conversation reflects a level of supervisory skill that deserves recognition. He acknowledged he had not yet reviewed the warrant. He explained the probable cause basis, which was the complainant's visible injuries and a witness statement, and he made no promises he could not keep. That probable cause explanation matters legally. Under Florida Domestic Battery Investigation Protocol, officers are authorized to swear a probable cause affidavit based on visible injury plus a corroborating witness, even without witnessing the incident directly. The warrant in this case appears to have been issued on exactly that basis. Now, the grades. The arresting officer receives a B. He executed a lawful warrant arrest, disclosed the charge voluntarily, used force consistent with Graham v. Connor, and followed post-force protocol correctly. The deduction comes from the initial delay in stating the warrant charge, which likely contributed to the subject's escalating resistance. The subject receives a C+. His refusal to exit the vehicle exposed him to an additional misdemeanor charge under Florida Statute Section 843.02. His physical resistance during extraction created unnecessary risk for both himself and the officer. His strongest decision was shifting to verbal engagement after the arrest, which is the correct approach. The sergeant receives an A-. His post-arrest dialogue was measured, transparent, and legally accurate. He explained the warrant process honestly, without either dismissing the subject's concerns or making representations beyond his authority. That kind of supervisory conduct is exactly what the job requires. Before we close, every interaction like this one carries lessons that apply far beyond this footage. Here are 5 of them, drawn directly from what the law and the facts on this camera reveal. Lesson 1. A warrant on the street is not the place to fight it. Under established Fourth Amendment precedent, the moment a valid warrant exists, your remedy is in court, not at the scene. Arguing with the officer does not suspend the warrant. It only adds risk. Lesson 2. The order to exit a vehicle is not optional. Pennsylvania v. Mims, decided in 1977, is unambiguous. Refusing that order transforms a lawful stop into a criminal resistance situation under Florida Statute Section 843.02. Compliance preserves your rights. Refusal compounds your exposure. Lesson 3. Officers are not required to explain a warrant before executing it. Many will, as this officer eventually did, and that transparency helps. But legally, they owe you no explanation at the point of arrest. Knowing this matters, because expecting it as a precondition for compliance will put you in legal jeopardy every time. Lesson 4. Use of force during an arrest is judged at the moment it occurs, not in hindsight. Graham v. Connor, 490 U.S. 386, sets an objective reasonableness standard. If you are resisting a lawful arrest on a felony warrant, a court will not second-guess the force used to overcome that resistance. Lesson 5. After an arrest, how you conduct yourself still matters. The subject in this footage shifted from physical resistance to calm verbal engagement after being secured. That shift did not erase the earlier resistance, but it is the kind of post-arrest conduct that can influence charging decisions, prosecutorial discretion, and ultimately outcomes. At the time of this analysis, the outcome of the criminal proceedings stemming from this warrant remains unknown. Based on what the footage and the applicable law show, the arrest appears legally valid, The force appears within the range authorized by Graham, and the subject's defense that the complainant's injuries came from a different source is a factual matter for a court to resolve. If you found this breakdown useful, consider what it would mean to understand these legal standards before you ever find yourself in a situation like this one. Knowledge of your rights and your obligations under the law is not the same thing. Both matter. And the gap between them is exactly where situations like this one unfold. If you have a body cam interaction or a legal topic you would like us to analyze, drop it in the comments below. Give this video a thumbs up if it helped, and make sure you are subscribed to our channel so you do not miss the next breakdown.